Welcome to Just Liberty, where liberty and justice meet. I'm your host, Alan Reinach, president of the Church State Council, here with my friend and colleague, Bettina Krause, editor of the very best magazine on religious liberty called Liberty. 120 years we're celebrating of Liberty Magazine. We're also, obviously, this is the new year. We're celebrating, as Americans, 250 years from the Declaration of Independence. And how fitting that our first recording of the year, we're going to talk about the First Amendment and free exercise. So why don't you introduce our guest?
Today, we are delighted to welcome Chris Beneke to the show. Chris is a history professor at Bentley University in Massachusetts. He's someone who spent a lot of time thinking and writing about the Constitution and religious freedom in America. And he's the author of several books, one of which is one of my favorites on the topic, which is Free Exercise. And this came out a couple of years ago. If you are interested in the origins of the First Amendment, I would suggest this is a worthy addition to your reading list. So welcome to the show, Chris.
Thanks very much for having me. It's a pleasure to be here.
Let me start with the absolute basics. Why did you choose this topic to write a book on? What led you to this?
So I had been writing about toleration and religious pluralism for a while and editing things about it, and had written a couple essays that were somewhat speculative about what the founders were thinking about on various topics like religious violence and the free market and how they related to religious toleration. And then decided at some point to consolidate that and to develop some of those ideas further. And a lot of it remains sort of speculative, based on the historiography, based on things that I had read over the years. But as a way to address sort of big questions about the founding and religious liberty that hadn't really been delved into in any depth before that point. Many had been broached, but not in the kind of detail that I thought might be helpful for readers and for jurists.
Well, the phrase free exercise may be a little less confusing than non-establishment, right? Because, I remember as a kid, we would play games with words like from, what was it, supercalifragilisticexpialidocious for Mary Poppins, and anti-disestablishmentarianism, which I had no idea what it was until I started studying, religion and the First Amendment. But free exercise, I don't know what it means to Americans today, but what did it mean in colonial days when, Madison and others are moving to protect, quote, the free exercise of religion?
So it probably meant something different than we oftentimes associate with today. I think it's oftentimes today seen as more or less identical with individual expression, identity, religious identity especially. At the time, in the latter part of the 18th century, it was strongly associated with religious duty, the obligation that believers had to their maker and to their community, and the things that they needed to do to fulfill their obligations, their foundational obligations. And so to exercise religion was essentially to manifest that duty in terms of public observance of faith. There were people at the time who wanted a more open-ended kind of expression, like individual conscience or religious liberty itself, but they settled on free exercise, which does suggest certain constraints on what they actually thought needed to be protected. But clearly, that protection had for them to extend to the practice of religious faith and its various manifestations.
So, today in American law, the courts have rejected the notion that they only protect, that the First Amendment only protects religious obligation, right? So religious expression or religious practice, it will be protected, at least in theory, regardless of whether it is absolutely obligatory, right? So, for example, if a more progressive Jew wants to wear a yarmulke, but doesn't see it as the same kind of legal obligation that an Orthodox Jew would. It won't just protect the Orthodox Jew wearing his yarmulke because he feels it's a religious obligation versus the more, less religious Jew who wears it um, without feeling like, oh, well, I'm, violating the law or breaking God's law if I don't wear it. But what did in the founding generation would they have made that distinction between the obligation or simply something that's done as part of your religion?
That's a good question. I'm not sure they gave it a lot of thought. And they also had sort of conflicted views, too, when it came to their general regard for religious observances. You're probably familiar with how tepidly George Washington engaged in religious practice. And he was not alone in that. And some of the other leading founders, too, were not big fans of religious ritual or ceremony, as they sometimes called it in Great Britain and Europe more broadly in the late 17th, early 18th century. There was a high degree of disdain for religious ceremonies that seemed like they're based on superstition. For example, Catholicism being one of the things that they would identify as superstitious and based on ceremony. At the same time, they didn't see any reason to regulate it or restrict it unless it infringed on civil order and the peace of the public. So they thought that religious exercise was something that everybody was free to engage in and that it should remain so, but they didn't always have a very high regard for it.
So, Chris, the First Amendment is very much part of the American culture, mythology. Everyone is aware that we have this distinctive protection for religious freedom. It's an amendment that has influenced constitution writing around the world. Yet I was surprised when I read your book to discover just how low key the origins of this First Amendment were. I mean, originally it was not even intended to be the First Amendment, correct?
That's right. Yeah, it was intended to be the Third Amendment and ended up as the first by happenstance because the first two didn't get the requisite amount of support. So yeah, it came about with very little fanfare, and it was something that James Madison, who we oftentimes associate with it, had real reservations about, partly because he and his fellow conventioners in 1787 had concocted this delicately contrived mechanism known as the Constitution and really didn't want to alter it. Certainly not the basic skeleton of the document itself. They also thought that most of the important decisions were going to be made at the state level, that's where individuals interacted with the state, the administrative apparatus of the state more regularly. And thirdly, and this is one of the points I really do try to get across in the book, there was an assumption that the culture had progressed to a point, and Washington made this argument notably, that it wasn't necessary really to put things into constitutional language, that the general public supported religious tolerance, and that these kinds of endeavors or enterprises were going on at the state level, again, where most of the work was done. So Madison was somewhat reluctant to do anything about it, but as we were talking about before the podcast began, there was some very real political pressure on him, especially from the Baptists in Virginia, led by John Leland. And they refused to allow him to enter office or to exercise any real influence over the Virginia Convention first and then later Congress, unless he committed himself to protecting religious liberty, especially. So he went along with it. It wasn't as though, and the last point I'll make here quickly, it wasn't as though he had lost his enthusiasm for rights. He remained an avid supporter of liberty, especially religious liberty. He just didn't think they were entirely necessary, and that the way things were trending, people would have those rights protected in other ways.
Well, and that ties in with the follow-up that I wanted to ask, which is, you mentioned Washington's ambivalence about specifying rights. my understanding is that the perception, at least by some, the perception of the Constitution was that it did not give to the federal government any power to infringe on those rights. And today, there's kind of a sense that, well, the First Amendment permits government to do things with respect to religion, to promote religion or what have you. But I think the founders would have been appalled at that notion, because what they were doing was, with the Bill of Rights, identifying specific restrictions on federal government authority that I think everybody kind of took for granted, which tracks with your observations in your writing about how little debate there was, little conflict there was over the language, because these were things that were pretty well agreed upon.
Yeah, absolutely. And the justification that Madison gives for the rights, when he does finally come around to arguing for them, is also somewhat tepid, where he says, we've got to do this thing, and we should do it in moderate ways, with moderate language, with generally with principles that everybody agrees upon. So it was not as though that he sounded in any way like an activist, a radical who was going to impart some very idealistic notion that he had and others did onto the Constitution. Instead, he was suggesting we've got a general understanding about this thing. We have people who feel very vulnerable in terms of their own rights. So let's add this protection. It may not be necessary. We know the federal government doesn't have these powers, but nonetheless, and he's speaking to his fellow Federalists in the first Congress, nonetheless, we should probably do this. And so it's undertaken with less than the sort of enthusiasm you might expect from such a what we now consider monumental enterprise.
It's interesting, Chris, because when I talk about the First Amendment and the Bill of Rights to different people, I say, this was not actually intended for most of you here in this audience. And that is an aspect of the First Amendment's history that you cover so well in your book. It wasn't intended for women. It wasn't intended for Jews, for enslaved folk. Can you, explore that a little with us now?
Yeah, sure. So there were, in one way, what they did during the Revolutionary period, and this aligns with how they proceeded generally, was radical in that they extended rights to people who were also generally white men that had not had them before. Roman Catholics, for example, Baptists, and Jews, they did not have the kind of rights before the Revolution that they did after the Revolution. But what it really rarely acknowledged were the majority of the population who were either white women or enslaved people, and there were also free black people too at the time, and Native Americans, who certainly did not enjoy the liberties that white men did. In most ways, on the issue of religious liberty, white women seem to enjoy a fair amount of it. The extent to which they were able to exercise it, though, within the family, within a household governed by men, where women could not own property, could not exchange property, could not vote, the extent to which that got exercised is still not clear. But it does appear that some women were very assertive in terms of their religious liberties, but it was subsumed under the weight of a patriarchal system. So it was only allowed, female religious liberty was really only allowed to the extent that a male member of the household, the father, the husband, permitted it. So the liberty was granted in many ways was not so much to individuals by the First Amendment and similar state measures as it was to families, to households during this time. When it came to those who were enslaved, that was entirely up to the discretion of those who enslaved them. They did give some discretion there, more than we might expect. So on various plantations in Virginia and elsewhere, some enslaved people were allowed to choose between the local Baptist church and the local Presbyterian church, which seems to be kind of extraordinary, but it was also a very limited kind of liberty. I mean, maybe even akin to allowing someone to have a garden a little patch next to their home, on a plantation. So it's not a lot, but it's a little bit, and it's informal. But it never meant that those liberties in a formal way were ever intended for them. So it's a messy picture, but it's one certainly where there is a big disparity between the religious liberty enjoyed by men, white men, heads of households, and those who were not.
I can't help but digress since you're talking about slaves to remember that there were versions of the Bible of it, that were provided for enslaved people that omitted the Exodus story, because God
Oh,
forbid,
Mm.
slaves would read about God delivering the Jews from slavery in Egypt, right?
Yeah, and it was, religion was seen as a means of social control too, in addition to having all the liberatory potential that it did.
Well, that has continued to this day. Of course, Karl Marx famously saw it that way, the opiate of the masses, so to speak. Um, well, the Supreme Court has recently really fixated on their phrase is history and tradition as kind of a foundation basis for how they interpret these fundamental rights. Um, you know, how do you, I guess, how do you see that um, making its contribution within First Amendment law? Do you think that that might change things dramatically, or?
Yeah, I think that, I mean, this obviously has been the case to one degree or another for the last several decades, and as you know better than I do, you both know better than I do. The Supreme Court has really only taken an interest in these matters, in the First Amendment in particular, since the 30s and the 40s. But and all along the way has relied on some conception of what the founders intended, and that has changed over time, partly because of the evidence available to them, what's considered good evidence in this regard, and interpretive frameworks that people have used. I don't know if that's ever going to change. I suspect we're going to need to rely on history, but I hope that it will be relied upon more as a way of disciplining our imagination about the era and checking us when we speculate too much about it, and reinforcing that people at the time were constrained and had different ideas, than we do, constrained by their own time and place, and had different ideas than we do. Doesn't mean that we can't take something from what they said, and that we shouldn't, our own interpretation shouldn't be informed by them, but with a heavy grain of salt, here, large grain of salt. Because the problems that we encounter, the administrative state, for example, the federal government is much larger, does many more things than it ever did before, mandates certain types of educational support and compliance, provides benefits that it did not in the past. All these things mean that there are many more touch points with individuals and communities and churches than there were in the latter part of the 18th century. And if anything, that's as big a difference as there is between our era and theirs.
I'm fascinated with this idea that people think that they can find this pure essence of the original public meaning, and in the internet age, everyone can be a historian, correct? I mean, they think they can. They think they can dig out the evidence that supports their particular position, their understanding of how the Constitution should be interpreted. In your work as a historian, what are some of the common misconceptions or myths that have grown up around the First Amendment that you wish that you could just burst?
Well, the obvious one is that the founders intended to completely separate church and state, that they intended to create a secular, more than just a secular government, but to keep religious and civil matters entirely separate. And we know that's not the case. That there was a fair amount of bleeding between religion and politics at that time, and many leaders did have strongly held religious convictions and invoke the Bible on a regular basis. So we know all that, and that the population generally is more religiously literate than ours is today, and that religious commitments, even if they were waning during this time, were probably still more meaningful for a lot of the population. So that's one thing that I think we need to bear in mind. Given the way, and I didn't think that I tended to discount how much Christian nationalism mattered. This idea that there was a singular religious identity at the founding, and that everything else should be submitted to it, and that there was a general conviction that religion should inform everything that people in the civil sphere did. That Christian nationalist conception of the founding, I thought, was limited to a very small number of people and not all that important. Until recently, when I started seeing Department of Homeland Security and Labor Department posts that pretty explicitly invoked Christian nationalist tropes. And so I don't know if this is ephemeral. I don't know, some of this is just meant to provoke. I don't know if it reflects a larger feeling in the public, but that Christian nationalist conception of the founding that was, included a singular identity, an aversion to diversity, a commitment to a certain version of Christianity. That's another myth that I'd say is now important.
Well, and I'm thinking too about the reading of the First Amendment that restricted only the creation of a national church, because that was actually a proposal that wound up on the cutting room floor, so to speak, right? That was rejected.
Yeah. So they had various possibilities that they entertained that weren't the ones they ended up with, and they ended up with language that was pretty vague about what they actually intended. But yeah, so one possibility was just to exclude a national church. One possibility was to actually regulate what the states did and prevent them from infringing on religious liberty. Another was to essentially allow each state to to do its own thing, and not to prefer any of them. It's called non-preferentialism. Was essentially to leave them be, and there are some evidence that that's where they landed in a way. But there was a certain secular impulse among the founders, that is to ensure that people were not excluded from civil losses. You can see this in Article 6 of the Constitution, which was there before the First Amendment.
No religious test.
The religious test clause, right? The only mention of religion in the original Constitution. And then generally among the founders, there was a belief that it should be a largely religious, secular institution, that it should not carry out doctrinal practice, or that it should not give physical or civic form to religious beliefs. That was pretty strongly held as well among many of the founders, is religious as some of them were.
And do you think that was propelled in part by the European history of religious conflict? Was that part of their thinking?
I think it was. So here's something that I discovered that was sort of interesting over the last decade or so. I assumed, and I think most people still assume, that the aversion to violence, that fear of religious violence, was a primary motivating factor during the revolution and the period thereafter. The thing is that by the 1770s, 1780s, people really hadn't seen much religious violence. And some of them even noted this. They said, well, when someone would bring this up, they'd say, one of the things we need to do is protect religious liberty because there's been so much religious violence. They said, where is it? Where is the religious violence? We haven't had it here in Virginia. We haven't had it across the colonies or even in Europe for 150 years, at least in a sustained way. So what had been really important to people's conception of religious liberty, you could say in the 17th century, it was central to their idea of religious. Those who favored toleration did so in part because memories of barbarities on a scale that we've hardly seen in human history were so fresh. Religious atrocities, massacres, because they were so fresh, they did have that top of mind. But by the end of the 18th century, it was more about taxes. It was more about recognition. It was more about the inconveniences that people would endure. That didn't mean, back to your question, Virginia, that didn't mean that religious violence wasn't still a metaphor they drew upon. It just took different forms, and it wasn't a direct referent to actual violence anymore.
So, your mention of taxes kind of gets me to circle back to this notion we talked about earlier, whether it was really only your obligation to God that was understood as kind of what we're going to protect. Because, of course, the Baptists were objecting not only to coerced taxation for religion generally, which would support somebody else's religion or somebody else's church. They refused to be taxed to support their own church. So there was a very strong, at least within the Baptist tradition, a strong concept of not just one's obligation to God, but that it be voluntary, that religion be entirely voluntary. And I think free exercise certainly, if our courts today want to go back to history and tradition, I would think that would be a principle that we would hope that they would respect.
Yeah, that's a really good point. And I've been sort of suggesting that we really only need to pay attention to Madison and to Jefferson and to Washington. But there were a lot more people alive at that time who had views about religious liberty, and many of them fell, and a growing number of them fell because a growing number were Baptists. Just that thing, that they did not want the state to in any way support religion because it corrupted religion, and that it should be done purely on a voluntary basis.
So I was encouraged by my faculty advisor to do an honors project on the Supreme Court's use of history. And as an undergraduate, understanding what has come to be known as law office history. And so when I see the court saying, we're going to go with history, I'm immediately suspect because, it's like Orwell's famous saying, he who controls the past controls the future, something like that, right? That it's easy, those in power write the history.
Yeah, that's a great point. And what we choose to focus on, the evidence we choose to use, makes a big difference. If I tell you that James, all about James Madison, but neglect, as I sometimes do, other influential founders, there are people, for example, who point to Roger Sherman, who was a deeply religious person, had less expansive views about religious liberty, still expansive, than Madison did at the time, a less secular conception of the state. But that could be somebody that we should give significant weight to. So I think there's a strong case to be made that the past is very complex and we should not simply delve into it in a way that simply supports our own views.
So we are celebrating America's past this year, 250 years since the Declaration of Independence. What do you think the First Amendment, what role has it had in shaping what we are today as a country? I mean, it may not have been passed with much fanfare, but it undeniably has had a significant role in shaping our culture, right? So how would you describe its influence?
This is a great question. I would say that its influence was significantly less than we might take for granted at the outset. But since then, for its first few decades, it had symbolic value at the time. But since then, in the 20th century, in the 21st century, obviously, it's had enormous amount of impact on the way that Americans live their lives, the way they think about their relationships to one another and to the state, that it has provided a model of liberty that's pretty expansive, and that the earliest conceptions of religious liberty, limited as they were by racial hierarchies, by patriarchy within the family, really have widened to include as many forms of faith, as many manifestations of belief and practice, religious observance, as you would find in any other kind of identity. And as the sheer variety of things that the First Amendment encompasses, it really is may not be paralleled in any other domain of life. And so it's a kind of model for religious pluralism in the United States and has been in many ways across the globe.
Well, Chris, it's been an absolute delight to have you on the program today. Thank you so much for being here. Thank you for your book. And hopefully we'll get a chance to chat with you again, because this is a topic that we have nowhere near exhausted.
Well, thanks very much for the opportunity. It's great to talk to both of you.
Bettina, what struck you about this interview in particular?
What struck me was the amazing legacy that our country has of religious freedom that we just simply take for granted. Just before recording this episode, in fact, I had to run upstairs to record this episode from attending a prayer breakfast, a national prayer breakfast, or a prayer breakfast that's put on by the North American division of Seventh-day Adventists. And it brought together people of different faiths. We had a Muslim addressing. We had a Catholic priest. We had a Lutheran. We had someone who is a Hindu. We had all these different faiths all together in one room. And we weren't there because we all shared the same beliefs. Far, far from it. We weren't there because we wanted to share the same beliefs, but we were there to affirm the principle that we could, in this country, live out our faith without fear and without needing to coerce anyone else to join us. We respect individuals' choice in matters of religion. And just talking to Chris today just brought home to me again how blessed we are as a country to have that principle as a founding principle.
One of the things that struck me, I had always understood that our founders, as students of history, saw the absurdity, for example, of English history in the 1600s, where the government went back and forth between Protestant and Catholic. And it's like, okay, you're supposed to have religion based on what government is in power. Imagine how that would work here in the United States with a presidential election every 4 years, if we had to change our religion every 4 years based on who we elected, right? But that actually had somewhat receded, and it was as though pluralism was now assumed, and that the First Amendment was really quite unremarkable. It was regarded as, well, yeah, we all agree, but we don't really think it's necessary because, after all, the government has no delegated power to infringe on our rights or to prefer a particular religion as a federal government under the Constitution. So, thinking again about the history of those times, very, very, very needed as we are entering our 250th year and all of the celebrations of it.
Yes. It's interesting, Alan. I'm not sure if I read it in Chris's book or somewhere else, but the folk who lived at the time of the passage of the Bill of Rights, 1791, they were not shocked by the idea of religious freedom as found in the First Amendment. What shocked them instead was what happened 2 years earlier with the passage of Article 6 in the Constitution, no religious tests for public office. Because for many people back then, that was where the rubber hit the road as to how far your participation in civic life could go if your religion was out of step with the majority religion. And so that guarantee of no religious test for public office, in many ways, that is even more foundational to religious freedom, to our idea of religious freedom in America than even the First Amendment.
Well, and that kind of cuts two ways, because there were colonies like Massachusetts Bay, for example, where clergy were excluded from public office specifically. Yeah. So not only did the Constitution permit infidels or Catholics or anybody, but did not exclude clergy. So it was kind of, you know, regardless of your amount of religion or lack of religion, you could still serve in public office.
Yeah. You know what also struck me, Alan, with the conversation? And that is just how impossible the task is to find a definitive original public meaning for all of these constitutional provisions. I mean, really, if we are going to insist that we've found, the absolute meaning of any of these things, I think we're deluding ourselves.
Well, okay, but at the same token, I think especially we didn't really touch a lot on the Establishment Clause,
No,
but
we didn't.
I would dissent from the notion that he expressed that we don't really know much about what the founders meant by no establishment of religion, because they had very specific experiences of religious establishments, of tax funding, of paying salaries for clergy, of regulating, preachers had to be licensed in certain places. So there were a number of very specific things that when they said establishment, they were thinking of. And one of my favorite books is Leonard Levy's book called The Establishment Clause. And I liked it because that was the approach that he took to understanding it. And before I had read it, I had done an undergraduate paper taking the same approach, obviously not nearly as comprehensively as he did, but it was, a good start.
Great minds, Alan. Great
Like
minds.
like they say about 75 lawyers buried up to their necks in sand. It's a good start.
Well, I think that's it for our conversation today, and I hope you have enjoyed it as much as Alan and I have. Until next time, remember, the price of liberty is eternal vigilance. We'll see you next time.
Amen to that.